The court has 93 days at its disposal. No, you had your opportunity. Now it's my turn. Court recalls the people of the state of Michigan versus Edward J. Reed Jr.
Yeah.
Mr. Hartel, was the third time a charm?
It is, Your Honor.
All right. Where are we at with the case, Mr. Hartel?
Yes, Your Honor. I have reviewed with my clients and the people, and we would accept their offer as a no contest for civil liability if the court were so inclined. I do believe that would be appropriate.
What's the potential for civil liability?
There was a crash involved, Your Honor.
All right. Ms. Dull, any objection to the no contest?
No, Your Honor.
All right. Mr. Reed, have you heard what the attorneys have said the resolution in this case is?
Yes, sir, I did.
And did you have ample opportunity to discuss that issue with Mr. Hartel?
Yes.
Now, it's my understanding that you'll be pleading guilty to to 2 counts. One will be a driving while license suspended as a first offender. That is a 93-day misdemeanor and or a fine of $500. Additionally, you'll be pleading no contest, to count number 2 of reckless driving. That also is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Now, I'm being told that this is a no contest plea due to civil liability or potential civil liability, which means that you could be sued for your actions in this case. And it's my understanding there was some sort of an accident involved. The no contest plea allows the court to review a document, and it looks like it's going to be a police report to determine whether or not there's a factual basis to accept the pleas and for sentencing purposes. Do you understand that?
Yes, sir.
Back on October 7th of this year, were you on probation or parole?
No, I was not.
Were you on bond at all?
No.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Let me put your hand down. Now, do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes.
Did you understand those rights?
Yes, I do.
Most importantly, do you understand that you have a right to a jury trial in this matter, and that by entering a guilty plea, you'll be giving up that trial and you won't have you'll be giving up that right, and you won't have a trial of any kind. Do you understand that?
Yes, I do.
Other than the plea agreement, has anybody promised you anything in order to get you to plead?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then, Mr. Reed, to the allegations that on or about October 7th, 2025 in Selma Township of Wexford County, how do you plead to, in count number 2, reckless driving? And I expect that'll be a no contest plea.
No contest.
How do you plead to an added count 3 of driving while license suspended as a first offender? Again, I anticipate a no contest plea.
No contest.
All right. Counsel, I have been provided with what is marked as People's Exhibit number 1, which is a report from the Wexford County Office of the Sheriff, case number 83-2501837. Are the people moving for its admission?
Yes, Your Honor.
Mr. Hartel?
As a we, Your Honor.
People's 1 is received. Give me just a moment to take a look at that. The council believe that People's Exhibit number 1 provides a factual basis in which to accept the plea and the court rules have been complied with.
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. I also find the interests of justice are well served in allowing the defendant to enter a no contest plea due to potential civil liability arising from the traffic accident. In particular, I find in People's Exhibit number 1 that on October 7th in Selma Township, which is at M115 and 13th Street, there was a traffic accident. Witnesses in which Mr. Reed was the driver of a vehicle that had swerved around other vehicles at a intersection and then proceeded into the intersection where an accident took place. Additionally, at the time of the offense, Mr. Reed's license had been revoked. As such, I find that there is a factual basis. And Mr. Reed, I find you guilty of driving while your license was suspended, revoked, or denied, and of reckless driving. Pursuant to the plea agreement, the second subsequent offense for the driving while license suspended will be dismissed at the time of sentencing. Are we able to sentence today?
Yes, Your Honor.
Is there any victim input at all?
No, Your Honor, we have not received any response.
All right, Mr. Hartel.
Yes, thank you, Your Honor. We do, of course, appreciate the no contest for civil liability and all the understanding with the tech issues we had a moment ago. My client does, of course, appreciate the reduction from a 1-year misdemeanor down to, albeit 2 93-day misdemeanors. Just so the court is aware, he's only currently lodged for unrelated matters. He has an FOC issue, which I believe he's going to request an attorney for later. We don't know how that's going to resolve because that hasn't been heard yet. In my experience, they are generally released later the same day for various reasons I won't get into in this court. But I would ask the court to consider this being a situation of fines and costs. I would like the court to know that he does have medical appointments coming up in the next few days, I believe in the Grand Rapids area, if I recall correctly. He does have a wife that I've met before who I believe will be the one transporting him to those appointments. Very nice woman who I don't doubt would be in court today, but for the fact that he was not expecting to be lodged presently is the way I'd phrase that, Your Honor. But I would ask the court to have this be a situation where, because the court does start with the presumption of no jail or no probation, I do believe this would be appropriate for a situation where it is just fines and costs. However, if the court was on the fence between jail or probation so that he could get to those other very important medical appointments, he would rather have probation than jail. But again, I would ask for fines and costs. Thank you.
Thank you. On behalf of the people.
Thank you, Your Honor. Mr. Reed Jr. has a long history of driving while license suspended offenses. This is not his first or second time. He's been doing this for quite a while, spending many years. I believe some consequence is appropriate in this case, considering his history with this and considering that he ran a red light and himself and another person were injured as a result of his actions and as a result of him continuing to drive while the state of Michigan told him he is not allowed to drive. He is not eligible to drive. So I would ask the court to either impose some jail time or probation in the court's discretion. But I believe some consequence in this case is appropriate considering his long history of driving when he shouldn't be. Thank you.
Thank you. Mr. Reed, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
I'd just like you to know that my insurance did cover the other people. I am very sorry towards them. I did not swerve. I did not, and I want the court to know that I did not. The reckless part, I lost my brakes. It was an equipment failure, but there's no way that it was able to be told afterwards. So that's all I have to say.
Okay. Mr. Reed, do you know what you have to, is getting your license even a possibility?
Right now, they tell me I have to wait 10 years because of my ticket again. Every time I get close to it, I get another ticket that obviously throws it back.
Well, you know what the solution to that is, right?
Yes, I do. Yes, I do, Your Honor.
And what is that?
Not driving.
And it seems like you would have learned that after, I don't know, the first 10 times, first 15.
Yeah,
By my count, you've got 22 driving while license suspended,
I have to work, Your Honor.
going all the way back to the 1990s.
Yes, sir.
Mr. Hartel is correct. The presumption in these cases are that there's no probation, no jail. And as a matter of fact, there's been some court cases recently that tell us that unless you have reasonable grounds, you can't put somebody in jail for driving while license suspended, or even put them on probation. And that we can't necessarily always look to the prior history for that. But if you can find reasonable grounds, then you are able to do so. You have 22 driving while license suspendeds in your past. This makes 23.
Yes, sir.
Also, the reckless driving, and I realize what you say, that it was an equipment failure, but it was a no contest plea. So I get to take the police report for what it's worth. You could have always presented that defense and taken your risk and gone to trial, but you pled guilty to that. So I'm left with that. You pled no contest. So I'm left with that plea and the police report that describes you swerving around traffic, going into an intersection and causing an accident. So I do believe there's reasonable grounds in this case. I don't know what I get putting you on probation for driving while license suspended or reckless. I mean, you're not supposed to be driving. There's no classes I can give you to tell you that you shouldn't be driving. There's no classes I can give you to get your license back. You have to wait another, at this point, over 10 years now to get your license back. So for the reasons that would be a 23rd conviction, that you caused an accident, that you were driving reckless, shouldn't have even been driving in the first place, I do find that a jail sentence is appropriate in this case. For those reasons, the court has 93 days at its disposal. No, you had your opportunity. Now it's my turn.
Okay.
The court is going to impose a 30-day jail sentence with 0 days credit. There is a $75 crime victims' rights fund fee, $50 state minimum fee. I will waive the fines and costs due to the jail sentence. Mr. Reed, because I have sentenced you to a period of incarceration, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney.
So what am I supposed to do about my doctors? Can I go yet? Or am I supposed to just be at your doorstep, eating off your doorstep?
Thank you, jail.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.